Welcome to The Debate.
Yeah, it's great to be here.
So, if you let a bank robber, use your driveway as a staging ground for a heist,
Right.
and you leave the engine of the getaway car running for them,
Yeah.
and you hold the gate open, are you an innocent bystander when the police show up, or, are you part of the crime?
You're definitely part of the crime.
Exactly. And that is the exact question facing the Middle East right now, and it is completely reshaping how we understand the rules of war.
It really is. And the stakes, they honestly could not be higher right now. We are dealing with the traditional concept of neutrality.
Right.
Which is just this idea that if you stay out of the fight legally has to stay out of your territory.
Right.
And it's the primary way, historically, that we keep regional conflicts from exploding into global ones.
But modern warfare makes that boundary incredibly blurry, which, brings us to the events culminating on August 24th, 2026.
Right.
Because following the U.S. and Israeli strikes on Iranian territory in late February of that year,
Yep.
Iran launched these massive retaliatory operations. But they didn't just target U.S. or Israeli soil.
No, they didn't.
They targeted American military facilities that were located across sovereign Gulf Cooperation Council states, across the GCC.
Right, and those host nations.
Exactly. So my stance today as we dig into this is pretty straightforward. If you host the bombers, you are part of the war.
Okay.
Iran's strikes represent a lawful exercise of self-defense under Article 51 of the UN Charter.
Mm-hmm.
And the logic is based on this source of fire principle. Basically, if a host nation enables aggression, they fundamentally forfeit their neutrality.
And I'll be taking the opposing view on this one.
I figured.
Yeah, well, my position is that stretching the right of self-defense to include sovereign third-party nations fundamentally breaks international law.
Breaks it.
Completely. These strikes, they exceed the strict legal boundaries of necessity and proportionality. By hitting host nations, the battlefield is improperly expanded.
Okay.
And we cross a very dangerous line into unlawful preemptive or, frankly, preventive aggression.
All right. Well, let's actually start with the bedrock here, because we have to talk about Article 51 of the UN Charter.
Sure.
Because Article 51 explicitly recognizes the inherent right of individual or collective self-defense if an armed attack occurs against a state.
Right, it's the core exception.
Yeah, but notice what it doesn't say.
What's that?
It doesn't say you can only defend yourself within a certain, geographic vacuum.
Well, no, but
If a barrage of drones originates from a specific military base in a Gulf state, international law does not require Iran to just, politely stop its countermeasures at the border of the country hosting that base.
I come at it from a different way, because we really have to look at the entire jus ad bellum framework.
The right to war.
Exactly. The international laws that strictly govern when a state is legally permitted to go to war in the first place.
Right.
And if you look at Article 2, Section 4 of the UN Charter, it generally prohibits the use of force against the territorial integrity of any state.
Any state, yes.
Article 51 is an exception to that rule, absolutely. But it is not a blank check to ignore a third-party sovereignty.
I wouldn't call it a blank check.
But any claim of self-defense, it has to rigorously satisfy two foundational pillars: necessity and proportionality.
Okay, but sovereignty isn't this magical shield for complicity.
It's not a shield for complicity, but
Well, let's look at how the UN General Assembly actually addressed this exact sovereignty piece back in 1974 with Resolution 3314.
the definition of aggression.
Exactly. Article 3F of that resolution explicitly defines an act of aggression. It states that if a state allows its territory to be used by another state for perpetrating an act of aggression against a third state,
Right.
then the host nation itself is committing aggression.
Well,
This is crucial mechanics, right? A Gulf state hosting U.S. strike packages cannot hide behind the shield of neutrality while its air bases are actively being utilized to hit Tehran.
right, but you are assuming total complicity on the part of the host nation.
If a base in a Gulf state is the operational source of a threat against Iran, that host nation bears legal responsibility.
But do they?
Yes, they are enabling the aggression. Therefore, the threat can legally be neutralized at its source. It brings us back to the idea of a co-belligerent.
Okay, let's talk about co-belligerency.
Yeah, under the Hague Conventions, which are, the treaties governing neutrality in war.
Right, dating way back.
Right. Neutrality is strictly conditional. It's a status you maintain through absolute impartiality. If a state knowingly places its airspace, its runways, its logistical infrastructure at the disposal of offensive military operations,
Yeah.
it effectively enters the conflict. I go back to my opening thought.
The bank robber.
Yeah, if you provide the getaway car and you hold the door open for the robbers, you can't just throw your hands up and say you are neutral.
Right.
You are a co-belligerent.
I'm sorry, but I just don't buy that.
You don't buy the analogy?
No, let me tell you why that analogy fails in the complex context of international relations.
Okay.
Because a state hosting a foreign military base is not necessarily acting as an active accomplice for every single operation that originates there.
I mean, they know what's happening.
Sure, the getaway driver is guilty, but hosting a pre-existing U.S. radar installation
Yeah.
or a long-standing logistics hub, that isn't leaving the engine running for a bank robber.
What is it then?
It's more like a city leasing a parking lot to the police and then getting bombed by a rival faction just because a specific police unit parked there.
Okay. I'm not entirely sure I agree with the parking lot comparison. Why not? Given the sheer scale of intelligence sharing and, airspace coordination required to run a modern air campaign, it's not just parking a car.
But legally, we have to challenge the threshold of what makes a state a co-belligerent.
Okay.
Merely having an allied base on your soil doesn't legally justify a barrage of ballistic missiles on your sovereign territory.
But if the missiles are coming from there...
Under international law, to legally target a host country under the paradigm of self-defense, the defending state...
So Iran's in case.
In this case, Iran, yes. They have to prove that the host country is unwilling or unable to prevent its territory from being used for attacks.
Right, the unwilling or unable standard.
Exactly. They have to prove the host state was basically helpless to stop it or actively complicit.
But they are unwilling and unable.
Are they?
Mechanically speaking, yes. That is exactly how these bilateral security agreements function.
Well, the host nations in the Gulf, they do not have operational control over U.S. strike packages.
That's true. They cannot just push a button and ground American bombers. So they are unable.
Okay. Even if I concede that point.
Which you should.
Even if we accept the unwilling or unable premise and view them as co-belligerents, you still run into a massive logical and legal wall regarding the timing of these strikes.
The timing?
Yes, because you still have to prove that the specific facilities being targeted were instantly and overwhelmingly threatening Iran at the exact moment they were hit.
Ah, so you're talking about the imminence requirement.
Exactly. Because this transitions us directly into the nature of the strikes themselves. We really have to draw a hard, critical distinction between preemptive war and preventive war.
Okay, let's unpack that.
Preemptive war is thwarting an imminent, immediate physical threat.
Right.
You literally see the bomber warming up on the runway or the missile silo opening, and you strike it to stop the weapon from firing.
Right, the threat is right there.
And that is widely considered legal self-defense. Preemption war, on the other hand, is destroying a potential threat that is not imminent.
Okay.
It's based on a belief that conflict is inevitable. Like, you bomb a runway today, so they can't use it next month.
Which the U.S. Department of Defense itself defines as distinct from preemption.
Right. So striking logistical bases in the Gulf to degrade general capabilities or to stop future hypothetical attacks.
Hypothetical?
Well, future attacks. That falls squarely into the illegal preventive category.
Okay.
And we rely on the historical Caroline test to define this.
Oh, the 1837 case.
Back in 1837, yeah. So during a rebellion in Canada, American sympathizers were using a steamboat called the Caroline
Right.
to ferry weapons across the Niagara River to the rebels. British forces crossed into U.S. territory. They seized the ship, set it on fire, and basically sent it over Niagara Falls.
Which is wild to think about.
It is. And when the U.S. protested this violation of its sovereignty, U.S. Secretary of State Daniel Webster established what is now the gold standard for anticipatory self-defense.
The Webster formula.
He argued that to cross a sovereign border to defend yourself, the necessity of that defense must be, quote, instant, overwhelming, leaving no choice of means and no moment for deliberation.
Right.
So bombing a radar array because it might track your planes tomorrow does not meet the Caroline test.
I see why you think that, but let me give you a different perspective on what imminent actually means today.
Okay.
Because the Caroline test you are relying on, it was formulated nearly 2 centuries ago.
Law is law.
Daniel Webster was talking about a wooden steamship chugging across a river at like 5 miles an hour.
Sure.
We are talking about an era of hypersonic missiles, stealth bombers, autonomous drone swarms.
Which makes things faster, yes.
The timeline from launch to impact in 2026 is measured in minutes, sometimes seconds, not days.
I understand the technology has changed.
So the standard of an instant threat, it must be updated to reflect the mechanics of modern military technology.
Updating a law is one thing, but completely erasing the concept of imminence is another.
But I would argue the theoretical basis for a broader interpretation goes back much further than the Caroline affair anyway.
How far back?
To the scholar Hugo Gratius, who is widely considered the father of international law. He recognized as early as 1625 the inherent right of a state to forcibly forestall an attack.
Okay.
When a Gulf base is an active, integrated node in a continuous campaign of strikes, the threat isn't isolated to the 10 seconds a missile is in the air.
It's not?
No, the threat is perpetual. It is always imminent.
That is a deeply dangerous expansion of the word imminent.
Why?
Think about the mechanics of what you're saying. If a threat is always imminent, then the legal limitations on war essentially cease to exist.
I wouldn't go that far.
Any state can justify attacking any rival at any time by claiming the rival's mere existence is a perpetual threat. And this is where James Fearon's rationalist explanation of war becomes incredibly relevant to our discussion.
The political scientist.
Yes, Fearon points out that states often launch these kinds of strikes not out of immediate overwhelming necessity,
Okay.
not to stop a missile in midair, but due to a fundamental commitment problem.
Explain how that applies here.
So the commitment problem works like this. Iran looks at the U.S. and Israel building up massive logistical dominance in these Gulf host nations.
Right.
Iran fears a future shift in the balance of military power because there is no credible third-party guarantor.
No global police force.
Exactly, no global police force to promise Iran that the U.S. won't use that buildup to overthrow them in 6 months.
Right.
So Iran has an incentive to attack now while they still have a perceived advantage, or at least before the U.S. is fully entrenched.
So you're saying...
They are degrading runways today so they can survive tomorrow. That is the commitment problem in action. It is attacking out of fear of the future.
I see.
So I have to ask you, are these strikes on Gulf bases truly stopping an ongoing physical attack in the moment? Or is Iran just trying to aggressively alter the future balance of power in the Gulf?
Well,
because if it's the latter, it is a preventative war and it is illegal.
I'm just not convinced by that line of reasoning because it slices a continuous war into isolated artificial moments.
Artificial?
Yes, it demands that every single missile fired must strictly align with a missile fired at them like 3 seconds prior.
That's the necessity part.
That's not how war works. It is the former. They are stopping an ongoing attack, because you have to view the conflict as a continuous whole.
But the law requires us to evaluate each use of force on its own merits.
Then let's look at a historical precedent that deals specifically with ongoing conflict in this exact region.
Okay.
The 1980s tanker war between Iran and Iraq,
Right.
and the resulting International Court of Justice case regarding the oil platforms.
The 2003 case.
Yes. So, during that war, the waters of the Gulf were heavily mined and neutral shipping was constantly under threat.
Mm-hmm.
The U.S. took military action against Iranian offshore oil platforms, claiming self-defense, after American vessels, specifically the Sea Isle City and the frigate Samuel B. Roberts.
Which struck a mine.
Exactly. They were struck by missiles and mines, and the U.S. argued that these oil platforms weren't just pumping oil.
Right.
They were being used by Iranian forces as command and control nodes to direct the attacks on shipping. So the U.S. destroyed them.
And it's crucial to mention that the International Court of Justice ruled against the United States in that case.
Well, yes.
They found that the U.S. actions did not qualify as legitimate self-defense under international law.
Yes, they did rule that. But William H. Taft IV, who was the legal advisor to the U.S. Department of State at the time, offered a brilliant critique of the ICJ's 2003 decision.
Okay, but he's arguing against the court.
Because the court was wrong. Taft argued that the ICJ's reasoning was dangerously flawed and basically ignored state practice.
How so?
Look at the proportionality argument. Proportionality in self-defense shouldn't mean a state can only use the exact same degree or type of force as the attacker.
Obviously not.
If someone shoots at you with a pistol, proportionality doesn't mean you can only shoot back with a pistol.
Right.
As Judge Roberto Ego argued, and this is vital, proportionality is measured by the force required to defeat and deter the overall ongoing threat.
Defeat and deter.
Yes, if taking out a massive radar array or a logistics hub in a Gulf state is what is mechanically required to defeat and deter the ongoing aerial campaign,
Yeah.
then it is proportional. It doesn't matter if an enemy plane was physically in the air at that exact second.
That's a compelling argument, but have you considered the ICJ's actual dicta in the oil platform's case?
There's side commentary.
Exactly. For our listeners, dicta refers to the judge's commentary and reasoning written into the opinion that while not strictly the legally binding holding of the case, it provides a critical window into how international law is interpreted by the highest court.
Sure.
In their dicta, the ICJ explicitly undercuts this broad defeat and deter standard you are advocating.
Right, they set the bar incredibly high.
They did. The court suggested that for an action to trigger the right of self-defense under Article 51, the initial attack must reach a certain threshold of gravity.
The gravity requirement.
Yes, they drew a hard line between the most grave forms of the use of force, which constitute an actual armed attack, and less grave forms, like a minor border skirmish or an isolated mine strike. Furthermore, the ICJ noted a lack of evidence that the attacks, like the mining of the shipping lanes, were aimed with specific intent at the United States.
Which is precisely the dicta that Taft dismantles, and I firmly reject the ICJ's stance on both the gravity requirement and the specific intent requirement.
You reject the highest court's reasoning?
Absolutely. First, the text of international law, specifically the UN Charter,
Yeah.
does not require attacks by regular armed forces to reach a specific, arbitrary level of gravity to trigger self-defense.
But without a threshold.
If a sovereign state's military fires on your territory or your assets, it is an armed attack, period.
But if we remove the gravity threshold, aren't we just encouraging states to escalate to a full-blown regional war over a single stray drone or border skirmish?
Not at all, because the response still has to be proportional to the threat.
Okay,
You can't nuke a capital city over a stray bullet.
fair enough.
But denying the right to self-defense entirely, simply because an attack wasn't deemed grave enough by a court sitting in The Hague,
Right.
it just encourages an adversary to bleed a state by 1,000 small cuts.
I see that risk.
Secondly, on your point about specific intent, international law expressly prohibits indiscriminate attacks.
Which brings in distinction.
Exactly. This brings in the principle of distinction, which is the absolute bedrock rule of armed conflict. It requires militaries to distinguish between combatants and civilians, or combatants and neutrals.
Right, you have to aim at a legitimate military target.
Exactly. And the mining of the Samuel B. Roberts during the Tanker War was an indiscriminate act.
Because mines don't see colors.
Right. You drop a mine in an international shipping lane, you don't know who is going to hit it. A state cannot claim immunity from retaliation simply because its attacks were not explicitly aimed at a specific target.
Okay, so how does that translate here?
Translating this to 2026, if a host state in the Gulf allows its territory to be used to launch a barrage of drones,
Yeah.
they can't throw their hands up and say, well, we didn't specifically intend to hit that particular facility in Tehran, so you aren't legally allowed to shoot back at our base.
Because they enabled the indiscriminate threat.
Yes. If you violate the principle of distinction and use force unlawfully, the victim state is legally entitled to defend itself at the source of the fire.
I hear the logic in that, I really do.
But
But by adopting this highly expansive view of self-defense, a view where the gravity of an attack doesn't have to reach a high threshold, where specific intent isn't required, and where the threat is considered perpetually imminent because of the speed of modern technology,
right.
you are effectively dismantling all the legal barriers that prevent total war.
I'll admit the idea of a perpetually imminent threat is terrifying. Because it does feel like a blank check for war.
It absolutely does.
But how else do we legally handle hypersonic weapons that can wipe out a command center in 4 minutes? You can't wait for them to launch.
We handle it by maintaining the boundaries we have, rather than erasing them.
Even if they're outdated?
When Iran strikes sovereign Gulf states, it is expanding the theater of conflict based on a remarkably broad, highly subjective interpretation of who qualifies as a co-belligerent.
Okay.
If simply hosting a radar array or a logistics hub makes you a legitimate target for a ballistic missile strike, then the concept of neutrality is dead.
Well,
Every regional conflict will instantly metastasize into a continental war because every nation has alliances and every nation shares intelligence.
right, the networked nature of modern militaries.
Exactly. The frameworks of necessity and proportionality, they don't exist to make war perfectly fair. They exist to put a ceiling on violence.
That's an interesting point, though. I would frame it a bit differently.
How so?
The ceiling on violence is maintained by states actually adhering to the UN Charter in the first place.
Right.
And adhering to the Charter means not allowing your sovereign territory to be used as a staging ground for aggression against your neighbors.
But the remedy for that cannot be unilateral military strikes on third parties. Let's zoom out and look at where we actually stand on this.
Okay.
My position remains that while the right to self-defense is an inherent right under Article 51, it is strictly bound by the principles of necessity and proportionality.
Which we agree on, just not the application.
Right. You cannot stretch those definitions beyond their breaking point just because technology has gotten faster.
Yeah.
Expanding the battlefield to sovereign Gulf states risks blurring the crucial line between legitimate immediate defense and unlawful preventive aggression.
Okay.
By striking logistical and support bases in third-party countries, the conflict fundamentally escalates beyond the legal limits of the UN Charter, effectively punishing states out of fear of future imbalances rather than immediate necessity.
And my summary is that international law is not a suicide pact.
Okay.
Article 51 and UN General Assembly Resolution 3314 support the fundamental, practical right of a state to neutralize threats at their source. When Gulf nations allow their territory and infrastructure to be placed at the disposal of another state for offensive operations, they forfeit their neutrality.
That's your stance.
They step out of the bounds of impartial bystanders, and they become active participants in the mechanics of the war. Therefore, strikes on those specific military assets are not unlawful aggression. They are a justified, proportional act of self-defense designed to defeat and deter ongoing threats.
Yeah.
You cannot supply the instruments of war and demand the privileges of peace.
I think one area where we clearly converge, and what this entire discourse illuminates, is that the traditional frameworks of international law are struggling right now.
Oh, absolutely.
From the Hague Conventions on neutrality drafted over a century ago to the 1837 Caroline test for imminence, these historical doctrines are under immense strain.
Yeah.
Modern alliance structures, hypersonic weapons, and over-the-horizon long-range warfare have created a geopolitical reality that the original drafters of the UN Charter could barely have imagined.
I agree completely. The intricate balance between sovereignty, neutrality, and the right to self-defense is being tested in unprecedented ways.
Right.
And the cracks in the system are starting to show. There is so much more to explore in the legal doctrines, the historical precedents, and the raw mechanics of warfare that we've discussed today.
Definitely.
But think back to that image of the quiet harbor we sort of started with. If a harbor is sheltering a warship actively firing its guns, is it still a sanctuary? Or has the shield finally become a target?
A question that redefines the rules of war.
Indeed. Thank you for joining us on The Debate.